You stayed that time under Rule 36. And we have people languishing in jail that would otherwise be out, with or without a pandemic. If the 120 days stayed in place, a lot of them would be on the street, except for maybe the most serious cases. And they're just sitting there and they have no idea when they're going to get released. It's just an open-ended time. Is there a point where the SJC is going to relook at that in terms of Rule 36 when we have people sitting there? I mean, it's easy to say that, the case says that, well, you consider the length of time and go in for a reconsideration before the judge because of that. Most of them are just saying no.
I don't know, however, how else to answer except to say that we're doing the best we can. It's a pandemic. Courts are not able to function necessarily the way that
I understand that, but people are just being held without any end in sight.
Well, but actually we've got protocols in place, right? Procedures where defendants can petition to have their case looked at again, right?
And
in light of the COVID-19 issue.
And they do when the DA stands up and says, Rule 36 is suspended right now.
But
and the judge says,
yep. It's not about the Rule 36. It's about whether or not they are, if the judge takes another look at the case in light of the COVID situation, whether the person should be released. And this is
kind of like the Long decision that had to correct a problem that's not working because we had a system in place to address that. And that's kind of where we're at.
Fair enough.
It's not what there are a lot of people being held, some of whom should not under 58A, which I think has to get relooked at some point. We can't leave these people in there indefinitely.
Oh, I agree.
And I don't think that even if you do get going with jury trials, it's going to be a long time before they're full steam. Just a thought. Okay. You started talking about hearings earlier, and you said that's going to come before us maybe next month or something like that. And so I don't want a response, but I'm going to talk about what you alluded to and some views that I have of it. And basically, and I talked to you about this before, it's motions to suppress, where I know that one judge tried to force somebody to go forward with the motion to suppress, and you issued a stay on that. You issued as a single justice. And then a second case went up, and Judge Gaziano denied a stay because they gave him a Zoom option, I think is what it was. You weren't being forced into court. You could do it on Zoom. Once again, 37 years in court, trying a lot of cases and doing a lot of motions to suppress. You cannot cross-examine someone on Zoom. I think it would be malpractice to try to cross-examine someone on Zoom. You were a Superior Court judge for a long time. You handled many, many motions to suppress in trials, and you've seen lawyers cross-examine witnesses. And there's a certain dynamic that takes place as that's going on in person. You would agree with that?
Oh, I thought you weren't going to ask me any questions about this.
Huh?
I thought you weren't going to ask me.
Just that part. You agree there's a certain dynamic that goes
Absolutely.
on, okay? That you can't get on Zoom, okay? So what some Superior Court judges are doing, and they're not pushing them in the district court. I haven't seen that at all. But they're saying, well, if you don't want to go forward with this in person, you can do it on Zoom. I'm giving you the option, but I'm not letting you out. Well, that gives you the choice of being an ineffective lawyer, something to think about, by doing it on Zoom, or potentially risking your health or someone else's by going in the court. And that's not a fair choice for a lawyer to have to make. Just something to think about when you're considering that decision later on. I'm sure that argument will be made. Okay. Now, those are the questions I had. And there were some other questions that the folks that testified to earlier that I said that I would go over a little bit. And I gave you those questions, but I'm not asking them in that format because they were a little confusing, I thought. But I think there was basically a couple of issues that they were concerned with. And mostly what it really came down to was access to justice. That people who are being foreclosed on, the foreclosure proceeding starts in a non-judicial manner. Courts aren't involved. And they don't have an opportunity to litigate certain parts of that foreclosure till after their house is taken and they're being evicted, or after, and they certainly don't have the opportunity when they do a hearing in the land court dealing with the issues related to people who may be in the military. I don't think they even given notice of that. And judges are supposed to be looking at whether these people really own the property. There's a lot of issues dealing with title these days and ownership of property and selling mortgages and splitting up mortgages among different people. And the courts addressed that. It was a recent appeals court decision I read yesterday. That came down in June, I think. And I guess what they're looking for is people, the Constitution gives you a right to your property, and people are denying access to court. Most of these people have no money. That's why they're getting foreclosed on, maybe as a result of predatory lending. They can't afford to pay the mortgage, and then they certainly can't afford to pay for a lawyer. What kind of things would you address with respect to access to justice as it relates to those three issues? And then I'm done.
Yeah, okay. I do think that access to justice is very important. It's important for pro se litigants, if they can't afford an attorney, to have some meaningful way of getting some help with their cases. In terms of the way that foreclosure works, it's legislative, right?
I agree with that. I said that earlier.
Okay, so we can all we can do is interpret the statutes.
Right.
And so whatever comes before us, we will do what we can with that. But in terms of there being confusion about what judges should be looking at and whether or not the procedures are being followed, I think that's something that could easily be addressed. So
how?
By having a conversation with the judges.
Okay.
Yeah.
You did say something earlier that I disagreed with.
That's not a bad thing, is it?
No, in this case it is.
Okay, let's hear it. Let's hear it.
You told me that Judge Gantz was Superman. You weren't Superwoman. I disagree with that. I think you're going to be a fantastic Chief Justice. I think you're going to be a great leader of the third branch of government. I commend you for accepting this responsibility, because what people don't realize is how hard SJC judges have to work when it's associate justices. There were only 7 of you. You have your whole caseload. You have all the committees that you're on. You're called upon to go to countless places for like bar association events and things like that. You're the face of the court doing that, and every single justice that I know of has been doing that on a regular basis, giving up a lot of their free time. And you just like doubled what you have to do. So I commend you for doing that, and I commend you for your public service. You are a fantastic Superior Court judge. You command the room whenever you're in it. You're soft-spoken, but people listen when you talk. No question about it. And you have been a Superwoman Associate Justice, and you're going to be a Superwoman Chief Justice.
Thank you very much.
Thank you.
Thank you, Councilor Kennedy. Appreciate that very much. I see Councilor Hurley, and I'd like to call upon Councilor to question the nominee.
Thank you, Lieutenant Governor. First, I would, after listening to Councilor Kennedy, indicate that he must have kissed the Blarney Stone several times in his life.
Mary, just once.
That's all you needed. But I would agree with what he has said about Justice Budd. In listening to everything that's been said, I received testimony from Sarah McKee, and I believe that went to all of the counselors. And my question is, has that been shown to you?
I have not seen it.
All right. Sharon McKee lives in Amherst, Massachusetts. She was a member of the bar in DC. She was a former federal prosecutor and a former general counsel of Interpol for the United States. After retiring from the U.S. Department of Justice, she came back to Massachusetts. In 2013, she served as Governor Deval Patrick's appointee for law to the legislature's Registry of Deeds Commission. And she has volunteered since then for the nonprofit Alliance Against Predatory Lending. In my 20 years on the bench, and before that and after that, I really didn't ever have anything to do with foreclosures or much to do with real estate, other than obviously a client of mine buying a house, I do the title and all that good stuff. I am appalled at what she has described has happened to pro se litigants in this area. And I would ask that the Governor's Council office make sure that you get a copy of this. This is testimony from someone who's got no edge. They've got no stake in the game, but has, I think, described in several pages the fraud that's going on in terms of Massachusetts citizens not being protected as it relates to their property rights. And the numbers are striking. She talks about before COVID, it was 400 foreclosures a month. And the concern that I have is that she talks about more in housing court than in land court, because I think they deal with different issues. But before the housing court got all these other courts, for example, in my court in Chicopee, people would come in representing a bank, and there would be a pro se litigant, and there would be a hearing in terms of having the defendant removed from the property by way of an eviction proceeding. And she talks in here about things that occurred and things that she saw herself. And I'm not looking for an answer from you today, but I would like a promise or a commitment that you put together a committee to study what's going on in our courts, to study what's going on in terms of these fraudulent foreclosures, and that you present this evidence to the legislature and say, we've got a problem here and we've got to fix it. Because what she's saying happened in terms of judges not treating pro se litigants correctly, I think there's critical issues here. Because somebody's not represented doesn't mean they don't have every right to their day in court. And issues such as not allowing a friend who may have some legal background but is not a lawyer sit at counsel table with the pro se litigant, these types of things are troubling. So I'm going to ask you for your promise, and I know that you'll keep your promise because that's your reputation, and you do really care. You can't do all this alone, but if you get a committee of people who have expertise in these areas of foreclosure and to re-examine pro se litigants, not just in terms of what goes on in probate court or criminal courts, in district court especially. If you can put those two things at the top of your list and come up with people with the expertise to make recommendations to the courts, to the court administrators, and to the legislature to change some of the rules that need to be changed, it would be very helpful. For example, I was told as a district court judge that if somebody is a mom and pop corporation, not making a lot of money, they can't come in and represent that corporation. Now, I haven't been on the bench in 6 years, but it seems to me that with that type of a situation where you've got the stakeholder, there should be an exception to that situation. She points out other problems in the land court that I don't think is an issue of anything but their procedures, which may be too old to deal with the realities of the present day marketplace. That should be looked at as well. And as I said, I will get this to you as soon as I can. It's 9 pages long. All right. You, smart lady, you don't need to listen to me read this to you, and I would not do that to you. But I think there's a lot of good information in it. Maybe you want to put this gal on the committee. That's one thing. Second thing, in terms of funds to operate, there's 3 branches of government. So I think I'd like to hear a commitment from the governor and lieutenant governor, as well as the legislature, that we're going to do something about the court system and the underfunding of the court system, which has been systemic for as long as I have been law. And I'm getting long in the tooth, to say the least. I know you can't comment on this, but with Kaczmarek and Foster, they are a disgrace to the practice of law. I don't know what's taking the Board of Bar Overseers so long, but they, as other people in the Attorney General's office, should be called to task for what they did. And I agree with Counselor Jubenville. It was disgraceful. And Judge Carey is a friend of mine and started with me in the district court. Certainly took those folks to task as they should have been. So I hope, and I know you can't comment on that, but after all of this having been said, why do you want the job?
Thank you, Counselor. I want the job because I think I can be helpful. We are facing so many different issues nationally and within the Commonwealth. I want to be part of the solution. I think I can be helpful. I think because I listen to people, I get advice. I don't think I know all the answers, but I do think that I can move us forward in this very, very difficult time. And I'd like to be able to do that.
Thank you. And I certainly think that you have the capabilities. As long as you can delegate and as long as you have people around you that you can trust and that are not in it for themselves. One thing I want to promise from you today, you are not going to hire another court administrator who's going to live in another state and administer our courts. That's an oxymoron, to say the least.
We're hoping to have a very experienced slate that we'll be able to pick from, and I absolutely agree that it's very helpful to have someone who knows the Commonwealth and knows the court system.
Thank you. And last but not least, I'm coming from the School of District Court Judges. You Superior Court judges, I liken it to District Court judges do short stories. We are the bakery where you take a number and you get something fast. You folks are the novels. You deal with the novels that take weeks and years and trials that last months and all that goes with it. But I want you to promise me that you will look at the things that are appealed from the district court. The district court judges have handled with a different eye than what is normal or expected in the Superior Court or the probate court. Each of our courts, whether it's the juvenile court or land court, any of them, we have different perspectives. We have different ways of operating. And I've seen more so appeals court opinions that have eviscerated district court judges, that the people that write them don't understand. We have to make decisions in split seconds. We get to hear a 5-minute bail argument and, you know, maybe a 3/4 hour dangerousness hearing or a 2-hour dangerousness hearing. And we don't have the time or the luxury of handling one case a day. We have a trial set up where we get scheduled 15 trials a day, and we're lucky if we can get through one. We have all different kinds of issues. And I think the issues that were raised by Counselor Kennedy in terms of the differences between the Superior Court and the District Court, all those things have to be taken into consideration with this whole COVID epidemic. And it's not one size fits all. There have to be different things dealt with. I'm going to suggest that you consider having a COVID czar for each of the courts that get together on a weekly basis after they have studied the difference in how procedures are done in these courts. So that if you go to a Superior Court, you can expect that the instructions have come down that are the same and that people are doing the same things. And there's an expectation for the lawyers that are going to all these different courts that things are going to be done the same way. And they may not be done the same way in probate court as they are in district court. But at least you've got 4 or 5 or 6 people who are looking at a particular type of court and saying, these are the things that work across the board. These are the things that we have to change and make different for each of these courts. So that's my 2 cents. As I told you, by the time they get to me, if a question hasn't been asked, I'm amazed, because I'm always last because I'm in District 8. But sometimes the first shall be last and the last shall be first. So hopefully I've helped out a little bit. I think you're going to do a great job. And one last thing. When I started my career, I was Eddie Hurley's daughter. And I know you're Wayne Budd's daughter. But my father admitted before he passed that he had become Mary Hurley's father. And I know the same thing is true, that Wayne Budd is your father.
Thank you, Counselor. Thank you.
Counselor Hurley, that was beautiful. Thank you very much, and all of the counselors for their constructive input at this time as you seek to take on these administrative functions associated with the position. Yes, thank Counselor
I
Devine.
had asked Lieutenant Governor, I had one question to ask you. But before I do, I just want to address a couple of things of my colleagues. First of all, with Counsel Kennedy, I share his concern about COVID, and I don't think anyone here is more concerned. I had 2 sisters that were stricken with coronavirus, one in a small Newton nursing home and one in assisted living. My sister Grace died, and my sister also struggling in quarantine. I agree with the counselor. I go into a restaurant and they take my telephone number. I don't know how you could work that out in the court, but I think it's doable. I know I talked with Judge O'Shea, and he had an attorney that came into the district court that was positive. So he had to go to the Taunton court. So, it is a problem. Nothing that you can solve. With the help of God, we'll get through this pandemic. It's just hard for me every time I see those statistics to know my sister is one of them. But let me just tell you, every council got this from Sarah McKee, every single one. And I'm going to give this to you today to take. And I spoke with Sarah McKee for 1/2 hour. We had a wonderful conversation. And she's a brilliant woman. And I was educated by her. And that's what I try to do on this job, and talk to as many people as I can. Having said that, you mentioned Woburn Court. And I've been seeing how the courts are doing, and God help us, it's so difficult. But I spoke with Michael Sullivan 2 weeks ago, and he told me they have missed 1,800 trials. How are you all going to ever, get through that? Okay, so what my question was, okay, first of all, I think the greatest program was having judges mentor, because there was someone that the council voted for years ago, and she was very rude to everyone, and the mentoring has helped. Okay, so I see that, and I'm following on that. Now, having said that, what I want to know is, would you recognize the necessity of in-service trainings for all of the judges who are going to see foreclosure-related cases? That's the housing court, the land court, superior court, and increasingly district court, as we point out the criminal violations today. And then, of course, the appeals court judges and the SJC judges themselves. We know this has not been before the SJC. And God rest Judge Gans, I know that he was in the middle of this, trying to recognize it. So I'm hoping that would you consider that, to do that?
I really like the idea of creating a committee, as Councillor Hurley mentioned, and getting the stakeholders together along with judges and other people, experts in the courts, to talk about what's going on, what the issues are, and how to fix them. I think that will be one of the benefits of being the Chief Justice. I'll be able to see that happens.
Well, I hope the in-service training, and that's not to demean any of the judges, but we're in new territory that you've never been in before, and it's going to get increasingly more. So I think the more all judges can learn, from the SJC down to the land court and housing court, I hope that will be part of that decision that you make. So again, I followed you for 11 years, and I've been proud for those 11 years for every vote that I've taken, because I don't have a crystal ball, and some judges have disappointed me, but you never have. And I'm just proud to be your district counselor, and I'll still be. So good luck, and enjoy it, in good health. And as I said, you're blessed with a wonderful, wonderful members. And, you all have been faced with something no other SJC, court has been faced with. So I wish you all good luck, and God bless you.
Thank you.
That appears to conclude the questions from the council. I do want to acknowledge the thoroughness, the respect that's been demonstrated, the professionalism of this process, and the input that each one of you gave today, and of course the hard work that you do that's not seen by the public in today's hearing, in your preparation and in your conversations with the nominee. I want to thank you all very much for your contributions to this process. It does show how a process that is government involved should work.
Can I say one more thing? And I'm going to have the pleasure to nominate you next week at our public assembly. What's better than that? Huh? Thank you.
I also want to thank the sound and video crew who did a really wonderful job today. Thank you all, and thank you to Dean Serpa. This is normally a room where it's very difficult to hear because of the obvious echoes, and you did a terrific job. I'm not making a joke. I really hope that they can come to our hearings. Okay, thank you. I also want to acknowledge our staff. Bob Ross and Lauren Green did an outstanding job in preparing for today. We thank you for your contributions as public servants. And we conclude in a day with a lot of great conversation, and I'm sure, Justice Budd, you have a lot of notes that you've taken and a lot of deliberation around what you learned today and will continue to learn in your journey going forward. We thank you. This does conclude our hearing. As Councillor Devaney stated, next week's assembly on November 18th is when we will take up the nomination for a vote of this council, and we look forward to that moment as well with all of you. So thank you. Be safe in your travels home tonight. That concludes our hearing of Justice Budd.
Thank you.